In a reversal, the Court of Appeal in Lagos has delivered a critical victory to a consortium of creditor banks, effectively reinstating the receivership and asset freeze against local oil and gas conglomerate Nestoil Limited. This judicial action comes barely a week after a federal high court ruling had temporarily allowed Nestoil to regain control of its operations and assets. The high-stakes legal war between a consortium of creditors led by FBN Quest Merchant Bank Limited and First Trustees Limited and Nestoil Limited, its affiliate, Nakonda Energy Limited, and their principal promoters, Dr. Ernest Azudialu Obiejesi and Mrs. Nnenna Obiejesi. The debt in question is a staggering amount, reportedly exceeding $1 billion and hundreds of billions of naira, resulting from various credit facilities. The legal saga has been a rapid back and forth. The controversy ignited in October when the Federal High Court initially granted a sweeping injunction that froze Nestoil's funds across multiple banks and placed the company under the control of a court-appointed receiver manager. However, in a significant procedural win for Nestoil, the High Court, under a new judge, Justice Daniel Siago, ruled on November 20th that the original injunction had lapsed by operation of law, having exceeded the statutory 14-day limit for an ex parte order after a motion challenging it was filed. This decision effectively lifted the asset freeze. But the lenders were not deterred. In a swift countermove, FBN Quest and First Trustees filed an appeal. Documents confirmed that on November 27, 2025, the Court of Appeal granted the application for an interim restorative injunction. This order from the appellate court reverses all steps Nestoil and its representatives took after the Federal High Court's November 20th ruling. Critically, it returns control of the company's assets and operations back to the receiver manager appointed by the banks. Furthermore, the Court of Appeal ordered a stay of all further proceedings at the Federal High Court, halting the case in the lower court. This means that for the time being, the receivership is back in force, the asset freeze remains in place, and the legal war is now firmly elevated to the Court of Appeal, where the next crucial hearing on the substantive motion and notice is scheduled for December 4th.